Welcome back to the 44th episode of the podcast, The Unknown. My name is Michael Volpe. I am reporting from Chicago, Illinois. That's in Cook County, Illinois. I write at michaelvolpe.substack.com. My broadcast partner is Richard Lutman. He's somewhere around Fort Myers, Florida. That's in Lee County, Florida, named after Robert Edward Lee. And he reports at Lutman.substack.com. We're going to get into it later, right?
Now, Mike, for now.
Well, he's having a little trouble with Substack. We'll talk about that later. And that's LUTHMANN.substack.com. We normally start with current events, but we've got Paul Boyne. Paul, before you speak, just very quickly, both Richard and I have covered your case. There's a blog. I think it's still in dispute, though. For the sake of argument, you wrote the blog was yours, and you wrote everything. It was called the Family Court Circus. It was primarily about Connecticut and other states' family court corruption. And every once in a while, you, for the sake of argument, would throw in that such and such judge gave custody to all of these terrible people. It would be nice if someone put a gun to their head. It'd be nice if someone used the Second Amendment. That sort of thing. Richard and I have gone over and over and over it that this is a political prosecution, that there's reams and reams of both Supreme Court and other appeals court case law that says nothing you did should rise to what would be called a true threat, which is the legal standard. But on top of that, I think this all started in the summer of 2023. I heard maybe possibly in September they're going to finally try this case. But I think at this given moment, more interesting than the facts of the case are the facts of the process. And so update everyone on what's been going on with your case. You're threatening to move. Why would you move? Why do you think that's going to help your case?
Okay, quick recap. We are still in spinning our wheels, going back and forth to status conferences with Judge Brown. There's no schedule, discovery's not complete, no particulars, drama rolls on. Everybody in Connecticut is working very hard to ignore Illinois and the finding in Relaford that this stalking statute...
Yeah, go ahead. Explain what is Relaford?
Relaford is a Supreme Court decision in state of Illinois written by Judge Freeman. And it's from 2017. Illinois had the exact same words as this law in Connecticut. And the unanimous Illinois Supreme Court struck it down as facially unconstitutional as applied to speech. End of story, First Amendment rules.
Mm-hmm.
All right.
And so you were charged under a dubious cyber stalking statute.
Well, let's just call it stalking. Yes, this is a stalking statute, the same thing that Illinois had, and you can't use it when it comes to speech. Right. End of story. And the District of Columbia said the same thing in 2023 in a case called Boone. And but Connecticut, Illinois, and DC obviously don't exist in the eyes of Connecticut. So everybody's go ahead.
Listen, for those who don't understand the legal process, well, you're charged in Connecticut, and there's another thing I think we'll talk about. You were living in Virginia, and I think even the prosecutors acknowledge that you committed the crimes while being physically in Virginia. But why? Or Illinois? How does that relate to your? How can you use something?
Well, it's a little thing called the Supremacy Clause of the U.S. Constitution, and followed up by the Full Faith and Credit Clause. And all right, and let me just tell you, in Connecticut, in 2022, the appellate court cited the Illinois case. So, the appellate court says that Illinois exists. Judge Brown's court obviously has a different opinion. And as far as being in Virginia, the state of Connecticut has said that I was stalking in the town of Hamden and Groton. That is what they filed with the court. I don't know how I did that. I was never in those towns, but it doesn't matter. Jack Doyle's a little short on details.
Hey, Paul,
you've
maybe you're a succubus.
right.
Maybe you're an apparition. You have a
All
magic
right,
power.
Oh, come
but
on, don't give it away.
uh, and you've lived approximately 20 years in the state of Virginia. But so I am right now in Chicago. Am I about to have you as a neighbor? You're threatening to move to Illinois and explain? Let's say, for the sake of argument, July comes and you're now a resident of I don't know, southern Cook County, Illinois. You got an apartment there. How how how
On Mike
how
Volpe's
would that
couch.
help? How would that help you? How would
Well,
that help
by
you?
by landing by traveling to the land of Lincoln, and cloaking myself in the 14th Amendment, taking all privileges and immunities of being a citizen of Illinois, who has declared Connecticut's law unconstitutional, I think that just starts the ball rolling.
All
So
right.
if I'm in
So,
Illinois, Judge Brown is going to have to admit that Illinois exists.
mhm. All
So,
right,
Paul, what about
okay.
this
So
case you
look,
have, Paul? You have a case against Ned Lamont right now that you filed, a separate case from your criminal case against Ned Lamont, the Connecticut governor, related to actions that he took where you believe he hoodwinked the Virginia governor. And that case was filed in state court. It's also, you made a motion to our friend Judge Dooley in the District of Connecticut on the same grounds. Talk a little bit about that. What's going on there?
All right. Well, let's take our dear friend Judge Dooley, um, who has now decided that when the governor of Connecticut conceals material information from the governor of Virginia, i.e., commits a fraud,
wait.
it
You just made a pretty serious accusation. What do you mean that
oh,
Ned
I'm sorry.
Lamont that
Let's re
that?
okay. I'll give it to you real quick.
Mhm,
Ned Lamont runs the executive branch of the Connecticut government,
mhm.
and two agents of that branch, Samantha McCord and her little sidekick sister, were dispatched to Virginia under orders of Jack Doyle to retrieve property that was seized in a raid that they participated in June of 22. And my computers were seized under a search warrant from the Fairfax County Circuit Court issued by
Wait, Paul.
Judd. Yeah.
Paul, it wasn't just participation, it was instigated by the Connecticut authorities. Is that
Well,
right?
yeah. I mean, Jack and Sammy wrote a lengthy
And
affidavit and
Jack
memo.
is the prosecutor prosecuting you. McCord
Yes,
is
yes.
the
The
cop.
ball.
Hold on. The cop
Okay,
from the
sorry.
Connecticut State Police who was running the investigation. Go
Right.
ahead.
So anyway, so they abscond with the computers, which violated the sovereignty of Virginia, violated the jurisdiction of the circuit court. All that seized property was under the control of the court until Sammy and her friend ran off with it, which violated the law of Virginia. It violated the full faith and credit clause. It was illegal. And
It
Jack,
also violates something called the silver platter doctrine, which I don't think you've brought up in your case law, but that's something you should look into too.
oh, that's a new one. I'll have to look it up.
What
Anyway,
is the silver platter doctrine?
There is no way that a government, one government or another, be it the federal or any of the states, can, by a constitutional infirmity or a violation of law, hand another state evidence to be used on a silver platter. So it's an extension of the Fourth Amendment's prohibition against the illegal obtained evidence, or even ultra vires obtained evidence, or ultra vires processes, which is the core of Paul's case. I can't go to New York and say, look, I've got, as a Connecticut law enforcement person, say, hey, I've got all this illegally obtained stuff, but I want you to rebaptize it through the execution of this warrant. So if it's wrong from the beginning, you can't hand people stuff on a silver platter. It was handed to the Connecticut authorities on a silver platter by the Virginia authorities, but the Virginia authorities obtained this stuff because Connecticut prodded them and because it was done illegally. So it's a silver platter doctrine issue. It does not exist in the United States under domestic law. You still have silver platter doctrine under international law. So an international a sovereign could give stuff on a silver platter to somebody in the United States, but you can't do it between the states and the federal government.
yeah, and that's a new one. I'll have to use that. Thank you very much.
I give you some homework, Paul.
So
Yeah,
let's
but
let's speed things up. So
yeah.
basically, you just argued that that Lamont and his crew lied to the state of Virginia in order to get you extradited. What, and then you have been filing things. So what have you filed to try to rectify this legally?
Well, we filed what's called the declaratory judgment action to get a declaration of a number of things that's gone on under this statute. And, it's a simple civil process, and it's very broad and very liberally interpreted. And it basically, you're asking for an interpretation of the law, which is a duty of the court to provide. And there we go. So we threw it on the civil court, and a guy named Judge Schumann ended up with it. And the Attorney General Tong is screaming up and down to dismiss the case because he says there's no constitutional question, and something else is even more ridiculous. But anyway, Schumann, I guess he is very well known for giving the government anything it wants. So he set it down to an oral argument on the 2nd of September on the motion to dismiss. But in the meantime, I dropped 3 motions to disqualify the Attorney General because I'm calling into question the doings of the governor, for which the Attorney General by statute is not allowed to represent him. So actually, Schumann wants Tong to respond to those motions by the middle of July, and who knows what he'll do on that. But
Right, I'm gonna
Schumann,
get, this is the motion to disqualify that you're referring to. I got that up on the screen, so go ahead.
I'm
Continue.
sorry.
Yeah, I got the motion you're referring to up on the screen.
Okay, so anyway, that's all in the air. And
So
who knows?
right now, is there a trial date set for sometime in September or no?
No, the
All right.
Brown says he wants jury selection the first week of September, but he said that last year too. I mean, we've been
All right,
through.
so is there something on the docket that says trial starts September 4th or no?
No.
No. Okay. All right. So this is a aspirational on the part of Judge Brown, who is presiding. When you say Brown, that's who you're referring to. Any other updates?
Let's see. We covered Dooley and the governor's suit, and everything before Brown. And the only other thing, my ankle still hurts. I'm still going around and around with why the heck my ankle is tagged with this thing.
They gave you an ankle monitor, even though you have no restriction on movement, and they put it on one ankle that nearly came off. So their solution was, well, okay, we'll remove that bad ankle, put it on on the other ankle, and now that ankle is being traumatized physically. You don't need to get the gory details, but it's not merely uncomfortable. It's requiring medical attention.
Well, it just goes to show that Connecticut will not recognize federal law. That's it. Okay. Simple.
Okay. All right, Paul. Thank you for being here.
Okay. Take care.